Someone make it make sense.
Probably a couple.
Y'all, I hope everything is okay with the audio. I feel like it's like StreamYard's having some problems again, but I hope that that's just my imagination. Let me put some music on. It just seems like it's being kind of glitchy, but hopefully everything is okay. Some night driving going on. Woohoo! Hope y'all are having a good week so far. So we are here to take a look at these Idaho documents, gearing up for that hearing on Thursday, which is the hearing for the motion to change venue. Yeah, it looks, I don't know, hopefully it's looking okay for you guys. Why is it looking weird on my end? Anyway, technology. So yeah, I hope you guys are having a good week so far. Those of you guys who've been hanging out while we covered the Ezra, was that we've had so many interesting things going on with that, and I'm really excited for the next episode of that. I'm hoping to have it ready for tomorrow. I'm going to do my best to have it ready for tomorrow. Because I'm so excited. We're going to be able to start Ezra on the stand. So there's that. But there's been a number of different squirrel holes, if you will, of trying to solve some different open-ended or remaining questions I'm working on. So is it cutting out? You guys, what is happening with technology? StreamYard, I don't know if it's StreamYard or YouTube. I keep getting this. I don't know what is happening. Hopefully it is okay for y'all. So, but yeah, so there's been a number of different things, and I do appreciate those of you guys who have kind of helped share the load, if you will, by taking on different portions of that and doing some going back to some of the testimony to help find answers to things, because as some of you may have heard, my list is like really super long. Let me turn the, I feel like it sounds weird. I'm turning the music off, see if that changes anything. But yeah, the list of questions is super long. So yeah, so we're going to go over those new documents. And then for those of you guys who saw the video I made, it wasn't a live stream, it was a video of the initial defense memorandum for the motion change venue. That was the one that was like 360 something pages long. I had mentioned at that point a game that we were going to play, the Control F Myself game, with the different keywords. So we're going to do that, I guess, probably at the end of the stream. We will do that, and you guys can get your guesses in. So, and yeah, so let me go ahead and share this to you guys. Share my screen here. All righty, so, and we'll jump right on in. As always, you guys, let me know if you have questions. I guess comments or concerns also are valid. But yeah, so we're going to start out here. This, by the way, this is the memorandum. This is the, sorry, 319 pages. This is the one, again, I already did cover this, but I have this pulled up for anything. So, but we're going to start out first with, hi, Dr. Bob. Dude, we have missed you. We have missed you. And if you are able to try to catch up on some of the Ezra McCandless trial coverage, we would love to have your great mind help us. We would love to have you join us on that, because again, it's a really good puzzler. It's a really good puzzler. And honestly, that crime scene, actually, I think it's, hold on, do I have your command right? That crime scene, we could use your help, because it is a real mystery. And we're going to delve into that in great detail probably tomorrow. So if you are able to, and if you can't catch up, if you can just join us at where we're at, part of the plan is we need to revisit a lot of this stuff because there's a lot of questions. regarding the timeline, regarding the crime scene. So the plan is to go through and cover that in great detail. But for those of you guys who haven't had a chance to catch up yet, I'm including Fender in this because Fender asked me specifically, can you do like a one stream recap? And I was like, I have another idea, but this would be applicable for Dr. Bob or anyone else who is deciding to kind of jump on in and hasn't had a chance to catch up and would like to join us. Again, I believe it's going to be tomorrow, but we're going to start out with going over those things that for those of us who have been deep into this, we're going to try to solve some of these questions. But for those who don't know anything, you could jump right on in and you're going to get a really good idea of what is going on. So yeah, so that's, I just wanted to mention that this trial, hopefully some other school friends will join us in the chat and let you know what they think. But this is just, this trial is great. It's a great trial. It's a great trial. It's a great case. It is awesome. And I'm just so glad that I'm getting to cover it. And I'm also just, again, shocked that no one else has done it yet. Really, really crazy because it's got a lot. It's really becoming, I mean, nothing's going to ever surpass Murdoch for me. I would say that this has got to be my second favorite trial, second favorite case after Murdoch, because that'll always be number one. Now, if he has another trial, I don't know yet how that's going to work in terms of my list. I guess it's going to be tied for first place. So, but yes. All right. So we're going to start out here with we would love to have you, Dr. Bob. And we've missed you. I hope you had a great vacation. And I hope Bandit is doing well also. We're going to start out here with this state's objection to the defendant's motion to change venue. And again, the hearing for this is going to be on Thursday, and I will cover it. So, and I don't think I'm going to cover it live because, as some of you guys know, Judge, the way they do that is it's streamed live. And once the hearing is over, the court feed ends. So if you want to pause it or go back or anything like that, then you end up losing the rest of the hearing. So I'm probably going to do it the way I've done the other hearings, where we do it like later that day or the next day or something like that. So that we have that opportunity to pause it or to go back and hear something again. So yeah, so it'll probably be that same night. I think it's on Thursday. So anyway, all right. State's objection to the defendant's motion to change venue, State of Idaho versus Bryan C. Kohberger comes now. We know who that is. Okay, so I'll just read a little bit of this introduction. Defendant has filed a motion to change venue, requesting that the trial in this matter be moved to Latah County, where the offenses took place, to Ada County. We know Ada County from Chad Daybell and Lori Daybell, some 300 miles away. To support his motion, he conducted a survey of prospective jurors in Latah County, Ada County, Canyon County, and Bannock County, but far from demonstrating that I don't think you're supposed to start a sentence with but. Right, guys? Right? Am I right? I mean, come on now, state. But far from demonstrating that a Latah County jury pool has been uniquely subjected to an utterly corrupted, in scare quotes, environment, as defendant argues in his brief, the data show that pervasive and wide-ranging coverage of this case throughout the entire state of Idaho has led to high case recognition among survey respondents across all 4 surveyed counties. So, okay, let's go on to the argument. So that's, we know what's happening. So, argument. Although the government generally must prosecute an offense in the county where it occurred, a court may change venue in 2 limited circumstances. And here they're citing these statutes from the Idaho criminal rules. I believe we have covered these on previous live streams, but they go ahead and cite the relevant portion of it anyway. First, a court must change venue to another county if the court is satisfied that a fair and impartial trial cannot be held in the county where the case is pending. Second, a court may, but is not required to, change venue for the convenience of the parties and in the interest of justice. In this case, defendant has asked the court to change venue on both bases. For the following reasons, the defendant has failed to show that either of these circumstances applies. So they're saying for the following reasons. So let's see, how many reasons are we going to have? Reason number 1, defendant has failed to establish that a fair and impartial trial cannot be held in Latah County. I don't know that I necessarily agree with that. This hearing is going to be spicy, guys. I'm having flashbacks. Let me back up for just one quick second. When I decided, for those who haven't heard this yet, when I decided to start covering this case was after they had that initial hearing on the motion to change venue, and they brought in that expert, Dr. Edelman, and that hearing was so fascinating and so spicy and so informative and so interesting. That is when I was like, all right, I can't not cover this anymore. And I wish I still have talked about going back and covering that hearing because the hearing was so good. However, guess what? We're going to get another one on Thursday. And who knows, it could be even better than the initial one. So we're going to have, like, I'm really looking forward to it. So yeah, so that's happening. And anyway, it'll be interesting. It got really spicy, especially between Prosecutor Santa, as he's called, Bill Thompson, and Dr. Edelman got real spicy. And they're going to be arguing, and this is going to be exciting. So yeah. All righty. Defendant has argued that due to pervasive publicity in this case, a change of venue is appropriate. Defendant further claims that the atmosphere, shout out to space, in Latah County has been utterly corrupted by media coverage. It is undisputed that the defendant has a constitutional right to a fair trial with a fair jury, blah, blah, blah. On a change of venue motion, it is defendant's burden to show a reasonable likelihood that pretrial publicity will deprive him of a fair trial. So that's important. That's the burden, right? We always talk about this. Who has the burden and what is the burden, right? Here, so let me just read that again. On a change of venue motion, it is defendant's burden to show a reasonable likelihood that pretrial publicity will deprive him of a fair trial. However, where pretrial publicity is at issue, a presumption of prejudice necessitating a change of venue applies only in the most extreme of cases. So can you guys see, this is so law-y, like law, I'm making law into an adjective. This is just, you know, right? So you can already see where this is going. They're going to have to go with their, cite different case law, right? What counts as extreme? That's going to be, I think, at the heart of this. That's going to be one of the many things. That's where I can see where this is going. Because in other words, I think that before you can go with, is there a presumption of prejudice? They're going to have to discuss, okay, so it only applies to the most extreme of cases. So what counts as extreme, right? Well, that's going to be completely subjective. But they're going to have case law. Both sides are going to have case law that they're going to use. So let's see what they say here. Quote, this is citing from Skilling versus United States. This is from the Supreme Court. That, quote, the mere fact that the crimes reported by the media are gruesome or memorable does not render the publicity inflammatory to the extent of requiring a change of venue. Or actually, sorry, that's quoting State v. Haddon. The United States Supreme Court has also explained that, quote, juror impartiality does not require ignorance. I feel like that's kind of an offensive statement, but whatever. That is interesting. Juror impartiality does not require ignorance. Well, yeah, I don't think we want ignorant jurors, right? I mean, okay, in determining whether pretrial publicity has risen to a level that justifies a change of venue, Idaho's appellate courts look to a series of factors. Okay, so this is important. So this is actually what do we need to be keeping an eye out for, right? We can expect to hear more about this on Thursday, but this is what the Idaho appellate courts look for determining whether the pretrial publicity has risen to a level that justifies change of venue. The accuracy of the pretrial publicity. So here, what does the state have in their favor? Well, that I think the fact that there was a gag order, aka a quote unquote gag order, right, established really quickly, right? And then even though the defense has kind of wanted to use it both ways, that whole thing with Bill Thompson doing that press conference where he said, okay, everyone read the probable cause affidavit, read the probable, so you can have the facts, right? They kind of wanted to say, well, that's he poisoned the jury pool. I mean, in a way, right? I'm paraphrasing, but however, I still think that was a great thing to do because people are only going to speculate more if they don't have accurate information. And what's interesting is here, the appellate courts are saying the accuracy of the pretrial publicity matters. So here, in this case, the fact that, I mean, people are always going to speculate, but in terms of the publicity, because of the gag order and because of the those court documents being made public, thank you for that, Idaho, that increases the accuracy, right? So that bodes well for the state on that part. Next, we have the extent to which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence. The number of articles, well, we know there were a lot of articles here, right, from the memorandum. Whether the jurors were so incessantly exposed to such articles that they had subtly become conditioned to accept a particular version of facts at trial, that they're going to argue over, because I would say that in the defense's memorandum and with their experts, they're going to say that definitely is the case. What I don't know, what's going to be interesting to see is if the state is going to have an expert or somebody to try to rebut some of this, right? Like, because we have all these experts that we covered in this memorandum, and we're going to hear from them on Thursday. They have all these different experts, and they're all supporting this motion to change venue, right? It makes me wonder, like, is the state going to have their own experts to rebut? Like, are they going to have somebody come in and say, yeah, we also did a study and we surveyed people and, they had not become subtly conditioned? Or are they going to have someone else, like a psychologist or something, come in and say, they're going to argue over what does subtle mean? What does conditioned mean, right? I mean, it could come down to stuff like that. And then lastly here, it says the amount of time that passed between the coverage and the trial. So that's where the defense arguing that there's like continuous coverage on the case. That's where that's why they're making that argument, right? Because they're saying that it's not like, there's some cases where initially somebody gets charged with something and then you hear all about it and then you don't hear anything until the trial. It could be like a year or two, it settles down, whatever. Great example I can give you right now, just from my own experience, is Lisk, right? Rex Heuermann, like when that first broke, it was a big deal. We heard about it for a while. And there's been rumblings here and there. There's been other things happening, right? But for the most part, I haven't seen, like, personally me, I haven't seen anything about it in a while. And it's because there's probably not much happening, right? The next time there's something like a hearing or some sort of, court filing, or they find enough evidence, or they have enough evidence to bring charges on another body for, another something like that, right? Or of course, we've got the whole thing with the wife doing a documentary. I don't know. Anyway, so, but when something else happens, we'll hear about it, right? But when there's nothing happening, there's nothing to say. So what the defense had said was that in this case with Bryan Kohberger, that it's just been continuous onslaught, right? And I actually, when I made that video with this memorandum, I actually pushed back on that, and I gave an example, and I said, well, I actually was saying that I thought had been really quiet about it because nothing had happened. Just like the example I was giving with Lisk, where like, we had Karen Reed going on, and that was kind of consuming a lot. I mean, there's been a lot of trials, right? A lot of things going on for those who follow trials or, anything happening in the law. And in fact, to the extent of which there had been court filings in this case, and there might have even been another hearing. But I remember that no one had even brought it up yet. And I was one of the first people that I saw anyway to cover it, because everyone was just so distracted. Like, I think there was some big document, it might've been this memorandum that came out like while we were on verdict watch for Karen Reed, and while the jury was coming back with notes and stuff like that. Or actually, I think there was a hearing. Yeah, I think there was a hearing. The jury was coming back with notes and stuff, and like no one was paying any attention, right? And I brought that up because I was like, well, I don't know. So again, I think it's kind of like one of those things where, for the most part, when something else happens in this case, people are going to hear about it. But I will say from experience, even when things happen in this case, depending on what else is happening, people may not really hear about it, right? So anyway, but again, if the accuracy is really what matters, then, like, for example, people on LawTube, or people who are, squirrels like me, that when something happens, we cover it, right? But we're covering the legal documents, so it's accurate. Even if we do cover everything, which is what I've been doing, and it's my goal, it's accurate, right? So it shouldn't, I guess, if anything, in that case, it ends up being kind of like neutral, right? Like, shouldn't affect anything. Anyway, I think the accuracy and going over this stuff is important. So clearly the Idaho Appellate Court does as well. So good for them. Okay. United States Supreme Court has held that only in the most extreme cases, again, with that extreme, is a defendant afforded a presumption of prejudice based on pretrial publicity. And then they're giving an example here where this particular defendant had a videotaped confession that was aired on local news and, seen ahead of time, right? So he was interrogated, he gave a confession, and that was aired. I can think of a lot of cases that have had that same type of thing happen. But anyway, Not the case here. As we know, Bryan Kohberger wisely preserved his Fifth Amendment right and didn't say a word. I don't even think we know what his voice sounded like. So good for him on that. And then they give another example from 1965 where the judge allowed unmitigated camera access and included the filming of jurors' faces. I don't know why they're giving that as an example, because A, 1965 is not new case law, right? I mean, it's not your best example. And B, this is completely and utterly irrelevant. Like, that's just, I mean, I agree that they don't apply here. It's next sentence, but like, then why are you including it? Yeah, like he didn't do an interrogation. He didn't do a confession. He hasn't said a word, and we don't have jurors' faces because there hasn't been a trial yet. Like, that's, I don't know. I feel like they could have found better case law site, but whatever. Defendant in this case did not confess to the murders. Oh, keep reading, Chelsea, let alone on video. But right. Keep reading. Yeah. And it is the state's understanding that the court will not allow filming of the jurors' faces. Then why are you using these? Anyway, I guess they're saying the state is trying to say this is the type of extreme that is required in order to say that there's a presumption of prejudice. But they're giving examples that definitely will be in their favor, which is what you do, right? You know, I guarantee you there's plenty more examples though where they are relevant and do apply. Anyway, defendant urges his court to find that Shepard v. Maxwell applies here. Bedlam, I'm quoting it. Bedlam reigned at the courthouse during the trial, and newsmen took over. So, okay, this is funny. I'm going to read this because this is funny. Okay, quote, Bedlam reigned at the courthouse during the trial, and newsmen took over practically the entire courtroom, hounding most of the participants at trial within a few feet from the jury box and counsel table sat some 20 reporters staring at Shepard and taking notes. Well, I don't know what they're going to say next, but what I will say is, I mean, here it's italicized, right? Yeah, we haven't had a trial yet, so what are you going to say? Oh, they had set up, it looks like, okay, they had actually set up a table for reporters inside the bar. Says it's unprecedented. The bar of the court is reserved for counsel. Well, okay. I'm trying to see what their point is with this again, because it doesn't apply, right? Oh, right. This case is nowhere near the chaos present in Shepard. So why have they, okay, state, Idaho, prosecutor Santa, why are you spending 1 or 2 pages giving these lengthy examples of things that don't apply? Like, the facts aren't the same. You would be better off citing case law where the facts are similar and the situations are similar. However, the court found in the state's favor that a motion to change venue wasn't justified, right? Like, you're giving examples of things that aren't relevant. How is that helpful? Anyway, all right. The carnival atmosphere trial could easily have been avoided. Yeah, they're trying to avoid that. All right, this is silly. I'm going to keep going. As the case law makes clear, the test is not knowledge of the case, but rather partiality. Yeah, well, we know that's accurate, right? Thus, the fact that Latah County survey response had the highest percentage of knowledge about the case compared to other counties is far less significant than the fact that Latah County survey respondents had the least amount of overall prejudgment among the counties. Now, if that's true, I would agree. Knowledge isn't bad. Knowledge is power, as we know. And it says the least amount of overall prejudgment. However, I don't remember that being the case when I went over the thing. So let's see if we can find that. It says Exhibit B. Okay, let's find that. I wish they had like a table of contents on here. That'd be helpful. All right. It said, what did it say? Exhibit B. Right, Exhibit B, Appendix B. This is what they're citing. The state is citing this. Okay, so they're saying that Latah County had the least amount of overall prejudgment. Is that what they said? I don't remember that being the case. And we covered this phone survey. Remember? Do you guys remember Roberta? Shout out to Roberta. My name is Roberta. Is this what they're saying? Hold on. Scroll. Okay. 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 I think this might be what they were talking about. Volume of media coverage. Okay. Volume of media coverage. I think that I think they're talking about the part where they actually give their responses to this. Oh my goodness. Okay. It's in this area. I bet. Yes. Something. Okay. The thing is, okay, here's the thing. So they're saying the least amount of overall prejudgment. The thing that is interesting here is I feel like that's not accurate. Like, again, when I'm like, I thought to myself, I don't remember that being the case when I covered that memorandum. In fact, I don't, but I think it's because the way the data works is they give you a bunch of different factors, like this part, right? Like they give you all the different factors, but they don't just state I don't know that they can, like an expert can just say definitively, yep, they have more prejudgment or less, because I think there's like so many different factors. Oh, shout out to Black Witter. Glad you're here, my friend. So let's just see, is this the state just like jumping to a conclusion about it? Because like there's no, okay. These are all these are questions. So then where do you get to the prejudicial part? So okay. A study on the prejudicial impact of pretrial publicity found that 62% of jury eligible residents said they could be fair and impartial and decide the case solely on the basis of the evidence presented. However, only 39% said they could put knowledge of the media out of his or her mind. Again, that's fine. If knowledge isn't the problem, right? And then, of course, there's this whole factor of like, well, even if they say they can be impartial, does that mean they really can? Because of like implicit bias. So I don't know. Okay. Well, we'll hear them. And again, well, we have the defendant's response as well. So we'll see. They'll address it if there's a problem there. So the survey data provided by Dr. Edelman is inadequate to justify a change of venue. I don't know that I agree with that. It says it is not reported how many individuals declined to take the survey, raising serious concerns about non-response bias. This part, I think, is a good point, okay? A glaring omission in the data provided by Dr. Edelman is any lack of information about the number of individuals who were contacted but chose not to respond to the survey. So what they're saying here is that people who are deciding, people who will take surveys, right? Like here it says, individuals with high civic involvement are overrepresented in surveys. So people who are like, yeah, I'll take your survey. I'm one of those people, so I can speak to that. Such a phenomenon can easily play a role here, where at the very outset of the survey, respondents were told that they are being asked for, quote, opinions about an upcoming jury trial. So honestly, if anything, if that's how they started it, in my opinion, that would actually skew the data in a way that, that would skew the data in a way that would make you more likely to have people complete the survey who do know about it, right? And that would actually bode well for the defense. So I can see what they're saying here. I think they're getting at the fact that they started their phone surveys with this part, saying that they're being asked about opinions for an upcoming jury trial, was kind of already from the get-go going to skew the data, because it was going to, people who would agree to participate are people who are like, yeah, either I'll take that survey, like me, or they're like, jury trial, like they care, or they're not like waste of time, hang up, right? And I think that's a valid point. I think they would have done that. They should probably not have done that, by they, I mean, Dr. Edelman. The court must ask itself, would an individual who was asked for their opinion about an upcoming jury trial continue a survey if they had no opinions about upcoming jury trials? I mean, valid point, Prosecutor Santa. And once the survey started, would a prudent, thoughtful, and conscientious person who's reluctant to pass judgment with limited information opine to a stranger whether they believe a criminally accused is guilty of murder? So yeah, good point. This is just more about that. The court does not have complete survey data and therefore cannot adequately compare data among the 4 surveyed counties. As defendant acknowledges, this high-profile quadruple homicide case has, quote, captured the attention of the community, the state, the country, the universe, the galaxy, and even beyond the United States into other planets. I'm adding that there. Given the amount of attention that this case has received across the entire state, there are 2 critical questions on the defendant's motion to change venue. The first question is whether a fair and impartial jury can be convened in Latah County. And if not, the second question is whether an alternative county would better safeguard the defendant's right to a fair and impartial jury. After all, why would the court change venue to another county that has nearly the same media saturation as Latah County? So this is that point of like, well, if they've heard about this case on Mars, would it help us to move it to Mars? No. That's what they're getting at here. And again, it's a fair point, but you know what? I will say, we see this in every trial, right? Like they always manage to get a fair and impartial jury. So I think it's possible, but I still think they might need to change venue, but we'll see what happens. Okay. Well, we haven't heard all the info yet. Prosecutor Santa really likes using the word, likes talking about space in the galaxy, because this is the second time so far that I've seen him use astronomical. So in fact, Dr. Edelman's report focused primarily on Ada County as an alternative venue, despite the fact that Canyon County and Bannock County, the other 2 counties both surveyed, or both received astronomically less media coverage. I mean, but couldn't you actually give a percentage from the data? Like, I mean, I know it's fun. It's fun. Who doesn't want to think about space, right? But I mean, is it the most helpful or accurate? No. Hyperbole. And so now they're trying to give examples here of incomplete data. It'll be interesting to see what happens on Thursday when they respond to all this argument. It'll be spicy time. Okay. Additionally, Dr. Edelman discusses the phenomenon of minimization effect, which is when a prospective juror attempts to minimize the full extent of their exposure to pretrial publicity. This is the part, if you guys watched my video covering that memorandum, that whole thing, I made the joke about be a good juror, that a good juror versus bad juror. That thing, like they're like, I want to be a good juror, so I'm going to say that I'm not biased, that type of thing. That's what they were talking about. So, so they're saying here they didn't actually discuss that when it comes to other counties. They only discussed it in reference to Latah. Okay, let's keep going here. The majority of the survey focused on prospective jurors' knowledge of information already within the court record and admissible at trial. Now, I agree with them on that. Court record, right? Good, great. Let's get real information out. Let's get facts out, right? This is good thing, right? Defendant argues in his brief that this matter is an extreme case justifying a change of venue due to, quote, the continuous nature of media coverage, often inaccurate and misleading, the impact of the media coverage, and the small size of the community, end quote. And again, going back to the beginning of this document where they had the appellate court, Idaho appellate court, what their different factors are for determining. And remember, the very first thing was the accuracy of the media coverage. That's when I was like, yeah, good information is good. Accurate information, that's a good thing, right? And it's good for brains and knowledge, but it's also good for justice. So here, that's going to be a point of contention. And I'm going to be really excited to hear them argue about this, man. I can't wait. Because, again, this is a quote from the brief, the defendant's brief, right? Quote, the continuous nature of media coverage often inaccurate and misleading. So these are the different things they're going to argue. Like I mentioned already, has the coverage been continuous? I actually don't think it has, but they're going to argue about it. Has been often inaccurate and misleading. Well, again, people are always going to speculate. You can't stop people from doing that. But in terms of like mainstream media or like reporting, right? Like in reputable, sources, you can't stop people going on TikTok and doing stupid things, right? But like in terms of legit reporting, again, because of the gag order and because Idaho has said, here's the court documents, they're public, I think that it's really been on the more accurate side and on the less misleading side, in my opinion. But that's gonna be another point of contention, right? The impact of the media coverage and the small size of the community. So there's two other things there that were cited. But as Idaho's appellate courts have reportedly held, facts are prejudicial when they are beyond the scope of admissible evidence or inaccurate. Let me repeat that. That's important. Courts have repeatedly held facts are prejudicial when they are beyond the scope of admissible evidence or inaccurate. Citing Haddon again. During the course of Dr. Edelman's survey, respondents were asked whether they had read, seen, or heard about a series of factual information items related to the case. We've heard about this. We know about that. Right. About the cell tower, was he near the home, right? The knife sheath, all that. DNA, they're giving these examples. We covered all this. According to Dr. Edelman's report, 45% of Latah County residents responded yes when asked if they had read, seen, or heard that the defendant stalked one of the victims. The report did not indicate the response rate for the other counties surveyed. It's fair, right? It's fair. I'm surprised they didn't include it because it seemed like it seemed going through it, you're like, it's a lot of percentages, right? It seems thorough, but like, I guess they didn't include that. Okay. Okay, let's take a look at what else we got here. In any event, the substantial majority of the factual information asked of the survey respondents was not beyond the scope of what will be admitted at trial. That's fair. I agree with that. Most of the items were contained within the court record. Also agree with that. As to the prejudicial items related to the rumors that defendant had stalked one of the victims or followed. So what they're saying is the things that are court record are not prejudicial. Like, okay, and I can explain this because remember, we heard about this in the hearings so far regarding this motion to change venue, and we also read about it in the documents that the defense is saying, well, even if it is public record, things that were in the PCA, for example, could still be prejudicial. That's kind of like what they were saying. And that's part of why they were blaming Prosecutor Santa and saying, like, that's part of this is your fault, right? And remember, that got all spicy. So, and I pushed back on that. When I covered this memorandum and I read some of this stuff, I pushed back on some of the stuff. I'm like, like if they would give an example, I'm, paraphrasing, but they would give like an example of like, something that was a fact, like the DNA on the knife sheath, right? And then they're like, this is going to make people feel biased against, the defendant. And it's like, well, it is what it is. Like, I don't know. I'm not coming up with the right wording for that, but like, or like, oh, I know what it was. It was like if he was charged. It's like Bryan Kohberger has been charged with a crime. It's like, well, that's true of any defendant, right? Like someone's going to be charged with the crime, and then they're the defendant. I mean, so it's like you can't just say that that's prejudicial. So there's that. So the state is making a distinction here, right? Things that are just facts, like from the court record, that they are not prejudicial because they're factual and because they're court record. I agree. I mean, it's one of those things where it's like, well, it is what it is. Like, so, So it's not, I wouldn't say, so that's just, it is what it is. And it's factual. So as the prejudicial items related, so they're just making that distinction, saying that therefore the court, all that stuff is not prejudicial because it's factual. So this leaves you with the rest of the things, which would be like, for example, like in the stalking thing that they said. So things that were not part of the court record, right? As to the prejudicial items related to rumors that the defendant had, oh, keep reading, Chelsea, stalked one of the victims. There it is. Or followed any of them on social media. Less than half of Latah County residents reported even having heard of it. The data provided to the court demonstrates, if anything, the majority of Latah County survey response have not heard the most prejudicial and inflammatory information pieces outside of the court record, and that Latah County residents who had heard about the case were statistically less likely to prejudge the defendant. The court should decline the defendant's invitation to disregard long-settled precedent establishing voir dire as the proper procedure for addressing bias. Them's fighting words right there, man. That's a statement. Like, this isn't just saying here's what the court should do. This is also in this statement, there's a presumption that the defendant is saying that they should disregard voir dire, and that's not what they've said. That's not what they've said. This is the state being spicy. This is prosecutor Santa being spicy. The survey relied upon by the defendant did not even ask the response the most crucial question of all, whether they could set aside their biases and base their decision only on evidence at trial. Did it not? Instead, the defendant and his experts asked this court to simply assume that the survey respondents, and by extension all potential jurors in Latah County who've been exposed to media information about this case, are incapable of citing their biases. I thought they'd ask that. And again, the document is so I'm not going to go look for it, but I thought they'd asked it. I do know that whether they did or didn't ask it, they do end up saying, of course, that whole thing about implicit bias and wanting to be a good juror. And therefore, even if they say, yes, we can, it's like not reliable. That's what I know they said at least that much. In Dr. Edelman's declaration, he argues that a juror is professed, keep reading again. Holy crap. That's funny. The juror's professed ability to be fair and impartial, quote, should not be taken at face value in cases where there is a substantial prejudicial pretrial publicity. Oh, God. Right. Now they're talking about the dude with the death penalty stuff. Right. Okay. So, yeah. So there's the jurors, and like, are they just going to try to be good jurors and say the right thing? Then there's like implicit bias. And there's also this whole other factor that they're talking about here where worried about the community, right? Like that type of thing, backlash for the certain verdict and whatnot. Yeah. Y'all, this is insane. This is Santa, prosecutor Santa. I'm going to have to make a spicy Santa thingy to put on here. I'm going to have to do that. That'll be fun. Like for example, the way I have, just because we haven't done it in a hot minute, the way I have this, or the way I have this, I'm going to have to make a spicy Santa one. The problem with the defendant's experts, however, is that their opinions are directly contrary to the law. Ouch. That's yep, we do. Blackwater is saying, if I answered a survey on something I didn't know about, I'd look it up afterwards. Yeah, that's a good point. And that is a really good point. And honestly, that would, and I'm trying to remember if the state had brought this up before. It'll be interesting to see what happens on Thursday, man, because they could say that this, and actually now I'm like thinking maybe they did bring it up, that this survey alone, the fact that it's happening could have, contributed to poisoning the jury pool. So it's a good point. It's funny, right? You'd have to survey them again to find out. And then it's like, well, wait, now then it's just a domino effect. And now everyone's poisoned. We're all poisoned. But this sentence, the problem with the defendant's experts, however, is that their opinions are directly contrary to the law. That is a lot. Wow. Y'all, this is fine. They're going to be bringing forth the fire on Thursday. That's all I can say with this. This is going to be nuts. It's going to be a bloodbath, I think. Okay, let's see what else we got. The court can fashion remedial measures for jury selection short of changing venue. right? I mean, they've already talked about this. I'm not going to read. We already know. Judge, they've talked about this. That's not their best point. Even if the court were to find that a fair and impartial jury cannot be impaneled in Latah County, the court may impanel a jury from a neighboring county rather than moving the trial 300 miles south. So, right. That is a good point. Bring a jury in from a neighboring county versus move the trial to a neighboring county, right? Here, they're not saying neighboring, they're saying 300 miles south, trying to exaggerate the distance, or not exaggerate, but again, point out Idaho County, right? Being far away. So far away. Yeah. But when we'll hear them talk about it, but the thing is that is not ideal, because that's putting a strain on the jurors, right? That is really not, we ask so much of a jury. By we, I mean, the nation. And then to make them come from out of town, there's a reason that doesn't happen very often. I mean, I can't even think of an example where it has happened, actually. But I mean, if the neighboring county is 2 minutes away, sure. But okay, yeah, it would be more economical to transport the jury than to transfer the pending action. Yeah, but what about the jury, though, man? What about the jury? Summoning a jury panel from across the county line would incur far fewer costs and logistical issues than moving the trial to Idaho County. I don't know. I mean, also, you got to think about it that way, too. If you do that, your chances of having issues with jurors, I think that would increase, right? Because the more of a burden it puts on them, the more likely something could happen, and then they can't, I mean, maybe, I don't know. It could be risky. Transferring venue would not be convenient for the parties and witnesses, nor would be in the interests of justice. First, defendant argues that Idaho County's large population size has more than 10 times as many potential jurors than Latah County, and thus offers a larger jury pool to choose from. But the fact that Latah County is smaller than Idaho County does not mean that it is too small to select a jury. I'm going to make a note here, okay? So far, I don't know what else is going to be coming, but so far, they have not addressed what I think were the defense's strongest points from this memorandum. I don't, right now at this moment, I don't remember what all they were, but I listed them out when I did the video covering that. I think there were 6 of them. I was like, these I think are their strongest points. And one of them had to do with the fact that, I don't remember the percentages, but it was a crazy amount. It was a shocking amount of the percentage of the Latah County population, of the potential jury pool, the percentage of that was employed by the university and then that percentage was astronomical from what you would think. And then the other one was the percentage of people that would be in the potential jury pool who had law enforcement involved in the case. That also was way higher than you would think. It was crazy. And then there was the other thing too about the sheriff. What was it? There was some deal about the sheriff. Somebody was running for sheriff. I can't remember off the top of my head, but that was a problem. There was somebody from the school maybe was running for sheriff, and it was that I thought was another. Anyway, there were some good points in there, and they're probably timestamped. I'm sure they're timestamped. I just don't remember. It was a while ago I made that video, but anyway. So, but they're not. My point. They have not addressed any of what I thought were the strongest points yet. So we'll see. It just made me think of it when they mentioned that just because it's so small. And I thought, well, it's not that it's just too small. It's the percentages of the population that are wouldn't they already would be disqualified basically. Right. So they're just trying to say it's not too small. The small is not the problem. The small is not the problem. The only reason small is the problem is because the percentage, right? It's I'm just going to make an example. If you've got 25,000 people, right, that are in the potential jury pool, and there's 25,000 people, that have some sort of like, either they've got a family who's law enforcement in the case, right? Or they're tied in some way to something with the case, right? Where they would probably be disqualified. If you've got 20,000 people or 25,000 people that out of a population in a county of 2 billion, I'm making things up for the example, right? Right. Then that doesn't matter. But when it's 25,000 people out of 50,000 people, right? Then it's 50%. So it's not that it's the size that matters. It's relative, right? If that makes sense. So anyway, again, they're not really arguing. They're not discussing the real thing that was at issue, in my opinion. Oh, there's Lori Vallow, and Chad Daybell. The public interest in attending the Chad Daybell trial was so great that individuals who wished to attend had to apply online for a reservation the day before to get a ticket into the courtroom. Yeah. On cases of such tremendous public interest, there's unlikely to be any physical courtroom large enough to accommodate every member of the public who wishes to observe. Okay, so they're saying that the fact that Ada County is larger or the courthouse is larger isn't helpful or isn't a good enough reason. I mean, it's not a good enough reason. That's not the point. The point is because of the prejudice. But anyway. As to the size of tables for the attorneys. Oh my God, I remember this because I made a joke. I did not understand what they were saying, you guys. I remember this. I made a joke. When in this memorandum, they were talking about something about having enough room for like people sitting somewhere. And they were and then these were like, and even Mr. Kohberger. And I made a joke. I was like, how big do they think he is? And I didn't understand what the heck they were talking about. I was like, that was a real argument they were making about the size of the table for the attorneys. So I guess they're saying in Latah County, the tables are so small that they can't fit. There's not enough room for the attorneys and the defendant. I can't imagine that's true. I mean, we've seen them, right? We've seen them, the hearings. Anyway, I agree. There's no reason to think that the Latah County Courthouse or its staff is incapable of addressing these administrative and procedural matters. I agree. Yeah. Okay. We're getting to the end of this document. So let's just see if there's anything else. Again, they did not address, in my opinion, those the biggest and the best points from the defense. So maybe they'll be doing that on Thursday, but here we go. This is the part. Thank God. This is what I was talking about. The county, remember I was like the sheriff, right? Finally, the defense also asked the court to change venue on the basis that Moscow Police Chief Fry is currently running for Latah County Sheriff. Right. I thought this was a good point because this means he's politicking, right? Like this is, it just, I don't know. If elected as sheriff, Chief Fry would have the statutory authority to summon a sufficient number of trial jurors in the event that there is an unanticipated shortage. I just the fact that he's like currently, from what I understand, he's like in the process of like actually campaigning and stuff. I think that's a problem. I do think that's a problem. Okay, conclusion. Let's get to the conclusion. Defendant has failed to meet his burden of showing that the change of venue in this case is necessary and convenient. The court should decline his invitation to ignore well-settled precedent establishing the voir dire process. Again, I don't think that they said that. I think they're just exaggerating. The court should also decline to relocate itself, the state, and scores of witnesses hundreds of miles, and only to face another jury pool with similarly high media exposure. Again, the exposure is not the problem, right? State, come on, get it together, man. We know that the exposure is not the problem. It's the prejudice. It's the prejudice. So why are you saying that anyway? They could have finished stronger, I think, here. They, only to face another jury pool. They should have said with similarly high, prejudice. Defendant's motion should be denied. All right. Santa's signature. You guys, I thought that said itty bitty. Oh my God. Ingrid Beatty, there's prosecutor Santa. I'm gonna have to make a thing for Spicy Santa. It's gonna be Spicy Santa Day on Thursday. All right, so let's look real quick at this. So that was the state objecting to the motion to change venue. Now here's the defendant's reply to the state's objection to the defendant's motion to change venue. So the pressure to convict Bryan Kohberger is so severe that Latah County survey respondents said if he wasn't convicted. Wow, you guys, I just got goosebumps. Look at this. This is how they're This is how they're starting this document. I'm because this is epic. I'm going to actually read the preamble thing here. Comes now, Bryan C. Kohberger, by and through his attorney's record, hereby submits this reply to the state's objection to his motion for change venue. First sentence. The second sentence of this entire document says, the pressure to convict Bryan Kohberger is so severe that Latah County survey respondent said if he wasn't convicted, colon. These are quotes. These are quotes, and I read these, and this was, yeah. Quote, they burned the courthouse down. Outrage would be a mild description. They would probably find him and kill him. There would probably be a riot, and he wouldn't last long outside because someone would do the good old boy justice. Enraged, strong opinions, firing of officers, riots. Parents would take care of him. Wow. Remember, guys, spicy is going to be an understatement of heaven. Y'all, holy mackerel. The mob mentality within the community is the exact reason that statutory grounds prior to selecting the jury exist to move venue. Wow. The state brings forth no experts. So that answers my question, man. I was saying, I wonder if the state's going to bring forth any experts to rebut what their experts say. Well, here we go. The state brings forth no experts to counter Mr. Kohberger's. Interesting. Who are all clear, venue must be changed. Why are they bringing forth no experts, though? See, I was like, I thought of that, and then I was like, huh. But they're not bringing any experts? That's wild, man. The state does, however, acknowledge that Bryan Kohberger has a constitutional right to a fair trial with an impartial jury. Why are they not bringing experts? It's insane. Mr. Kohberger's motion to change venue is supported with a memorandum. Yes, we read all that. Again, well, like I said, they're going to be arguing over the burden. You know, where's the burden? What counts as extreme? The Idaho Supreme Court, actually, wow, on June 28th, 2024. Holy crap, that was recent. The Idaho Supreme Court pointed out that a change of venue, quote, is not an unreasonably high hurdle for a defendant to clear, but it does require proof of prejudice or a showing of reasonable likelihood of prejudice. The court also concerned with the accuracy of the pretrial publicity, right? The extent to which the articles are inflammatory, inaccurate, or beyond the scope of admissible evidence, the number of articles, and whether, remember what I said, you guys, keep reading, Chelsea. I said they're going to try to argue about this whole thing about how incessantly, right, are they exposed? And whether the jurors could look at this in italics, whether the jurors were so incessantly exposed to such articles that they had subtly become conditioned to accept a particular version of the facts at trial. And remember, I even said they're going to argue over incessant, they're going to argue over subtle, and they'll probably argue over conditioned, right? And I even said, I don't actually really agree with the defense on this because I don't think it's incessant, but whatever. Okay. I don't know. The amount of media coverage in Latah County is the highest in the state. I think that's probably true, but does not wane. I mean, I'm not in Latah County, but again, it's not incessant from, you know, my perspective. So publicity regarding Mr. Kohberger has been ongoing since December 30th, 2022. It rises and falls, but does not wane. Okay, well, at least they're admitting that, right? Rises and falls. Okay. That's a compromise. Unrefuted survey data justifies a change of venue. So this is exactly what I was saying, right? When I was like, you know what? The state's not even acknowledging some of the best points that they made. So this is the defense is saying the same thing. Unrefuted survey data. They're saying the same thing I said. Look at what they're saying. Don't look at what the state is saying is arguing. Look at what they're not arguing, right? That matters. The state's claims about the survey are wrong. Oh, I love this. I love this. Man, wow. Y'all. The state's claims about the survey are wrong. Dr. Edelman designed the survey questions and how, depending on the participants' answer, the order of questions would flow. The survey report lays out the questions and responses for all 4 counties and demonstrates that the survey was conducted exactly the same way in each county surveyed. The only difference is the number of participants. Wow. Okay, let me keep going. So The state's proposed remedies, expanding to Nez Perce County, vetting, or sequestration are not valid remedies supported by experts. Yeah, I don't even think I feel like there's not even been talk of Nez Perce County yet until the very end of the state's objection. Vetting as proposed by the state does not. Well, I fixed their typo. Vetting as proposed by these state does not work. Yeah, I fixed their typo. I auto-corrected. This reminds me of how many typos were in the other document, and it was really a lot. It was insane. For decades, the courts have recognized that simply because a jury of 12 can be selected does not mean that the jury is impartial. Right? This is why attempts to mitigate juror bias are best done, quote, when there has been less emotional investment and less publicity exposure regarding the case. Another issue with the quotes. Do you guys remember that when I covered this memorandum? That what is happening? How are they? Did they not watch my video? I even said, hey guys, I'll proofread your documents for you. Just holler at your squirrel. Holler at your squirrel, guys. I'll proofread. I can fix your quotations being backwards. I can fix your typos. I got y'all covered. I mean, but it's doesn't look good. Doesn't look good. And sometimes it can it can and did lead to confusion. I mean, there were so many in that other document. Okay, when asked how the community would react to a not guilty verdict, surveyors answered they would go on with life as always. I think they would take it well. I don't know if there would be super strong feelings. That's what the jury is. What? Oh, this is in Ada County. Right. So they're comparing the responses in Ada County to that in Latah County, which is what they started their document with, right? We went over that. They're saying in Ada County, these were the responses. This is a big deal. When asked in Ada County how they would respond to not the guilty verdict, they said they would go on with life as always. I think they would take it well. I don't know if there would be super strong feelings. That's what the jury is for, to decide based on the evidence. Wow. I think they would accept it. Yeah. I mean, rather than produce an expert, y'all, I agree. I agree with this. Why are they not bringing an expert? Rather than produce an expert who refutes the studies and opinions of the people, the state points to the cases that have not analyzed such research. Judge Boyce in State v. Daybell explains well how the case law dating back 50 years doesn't address the concerns of today. For example, again, that should say one, not once. One can only imagine what the justices who decided Irvin v. Dowd 50 years ago would have thought about that concern today, when every potential jury has access to limitless media, literally at the fingertips on a handheld device. Yes. Precedent in Idaho supports a change of venue. That's a good point. That's yes. 3 capital cases in Idaho have recently had a change of venue. State v. Lori Vallow, State v. Chad Daybell, and State v. Bryan. That's a great point, right? It was not just that Vallow and Daybell happened in Ada County, but yeah, they were a venue change, right? I don't know about this case. All cases stem from southeastern Idaho. The courts in these cases all granted a change of venue with a motion supported by evidence of extensive media coverage. I mean, I have to say, I kind of forgot that they got change of venue in Vallow and Daybell, but I mean, I really had forgotten about that. But you know what? I would have to say that even compared to those cases, Vallow, Daybell, I think Bryan Kohberger, I think the change of venue is even more warranted here, I would say. Probably. I mean, again, it's hard. It's different because I'm not local, obviously. But, I mean, I don't know. It's a quadruple homicide. And here's what I will say. When I talk to people who don't follow LawTube and don't watch trials, there's so many people, they've never heard of Lori Vallow or Chad Daybell. I don't know of anyone who's not heard of Bryan Kohberger. So that's there's that. Shout out to Cece. Glad you're here, my friend. Don't know anything about this one. Are you the wait? Do I need to eat my words? Are you the one person on the planet who doesn't know who Bryan Kohberger is? I will fall over if that's the case. Do you not know who Bryan? Do you not know that? I don't. What? I will literally fall over. Don't be sorry. You guys, y'all that are here, this is a miracle. I'm eating my words and I'm falling over because there you go. There you have it. There is someone who actually follows trials and watches, LawTube, who has not heard of Bryan Kohberger. That's a big, huge point for the state right there. Oh, I did not know you were Canadian. Okay, that's cool. Do you watch Runkle? I love Runkle. Although I've been making the joke over and over again that even if you go to Mars, you're not going to find someone who's not heard of Bryan Kohberger. So like, I'm pleasantly surprised, to be honest. So, okay. Conclusion. Let's see. Mr. Kohberger provided this court with extensive and unrefuted evidence. The evidence includes proof of excessive media coverage in Latah County that is both prejudicial and false, along with declarations of experts explaining why remedies other than change of venue are not enough. This evidence will be further developed at the change of venue hearing, which is on Thursday. The traumatized town of Moscow is understandably filled with deeply held prejudgment of whose guilt. Again, with this Nez Perce County thing, the issue of venue reaches finality with a change to Ada County because Latah County mob mentality will never produce a veneer. Or if you're in South Carolina, you would say, if you're in Poot, you would say venery, that results in a cross section of the community. What does that say? Weird. So here's some more stuff. Interesting. I actually have seen this case. This is I've seen that name on the Idaho cases of interest website where they have the court docs. Interesting that they're comparing it with this. I'm guessing these all got a change of venue. Let's see if they have Vallow or Dayball. Oh, they don't. Volume of media coverage over time. I don't know if these are additional exhibits or what, because again, we think that all this was in the other document, but wow. Solemnly, sincerely, and truly declare and affirm as follows. Okay. So this was the additional affidavit of this expert. I'm just looking to see what, well, let's see. Oh, so the point of this is to rebut some of the things said by the state. That's what they're having her do. Okay. Oh, okay. That's why. The non-response bias. So one of the first points made by the state was that they said was that the data was incomplete and therefore invalid because it did not include people who wouldn't participate. That's what it said, right? And I was like, yep, that's a good point. That makes sense, blah, blah, right? Like that's a point for the state right there. That because they said that they started the whole thing with saying, okay, this is a survey about a jury trial or whatever, right? Which that's a separate issue, but related. Separate but related. But they were saying that they did not include the data for those who wouldn't participate. That's what they're doing. They're saying, okay, here's that date. Here we go. Here you go. Okay, that's good. Good for them. Good for the defense. I'm still flabbergasted and dumbfounded as to why the state is not having experts to rebut anything. Very bizarre. Like, are they like what? I mean, maybe they just at the end of the day don't care if it gets a change of venue. I don't know. Right. This is what I was saying. Yeah, right. The court must ask itself, would an individual who was asked their opinion about an upcoming jury trial continue a survey if they had no opinions about upcoming jury trials? Yep. They're quoting this from the prosecution's objection that we just covered. Right, a good research participant. Okay, let me see what her point is here. Okay, so here's how, so this expert is addressing that concern, okay, with the placebo effect. Okay, cool. This is actually, I'm curious what she's gonna say. Telling a respondent exactly why you are doing, let me zoom in so you guys can see this better. I realize it's tiny. Okay, here we go. So this is addressing that argument from the state that they said, and I thought it was a good point, right, initially, where they're like, yeah, they said it. They told them on the phone, yeah, it's a survey about a jury trial, right? So then you're going to get people more likely who are like, yeah, I'll do it, blah, blah. Okay, here's what this expert is saying. Telling the respondent exactly why you are doing a research study is the opposite of scientific research protocol in a research trial due to the demand characteristics generated when such knowledge, wait, what? Hold on, let me reread this. Telling a respondent exactly why you are doing a research study is the opposite of scientific research protocol in a research trial due to the demand characteristics generated when such knowledge is given to the participant. I'm not understanding that sentence. What? Telling I'm going to just reiterate that in the last one, there were so many typos that there could be something amiss here. Just saying. Telling a respondent exactly why you are doing a research study is the opposite of scientific research protocol in a research trial due to the demand characteristics generated when such knowledge is given to the participant. If a participant knows exactly why the study is being conducted, that knowledge may influence their behavior. That is, the respondent may change their behavior or respond in a way that would give the researcher the outcome the respondent thinks the researcher is looking for due to social desirability to be a good research participant. I respond to this comment with the same reasons I provide above. Specifically, respondents may refuse to continue the survey for the same reason they might refuse to start the survey in the first place. And those reasons may have nothing at all to do with the subject matter of the survey. So she gave examples above. I need to find the examples. Where are the examples? Where are the examples? Okay. The prosecution argues that survey respondents should have been told exactly who was calling and asking these questions and why. What? Doing so would have created bias. Those who would not want a survey to be conducted related to this crime because they would not agree to a change of venue for the defendant, for example, would lead not only, there's so many typos in this, it's making my brain hurt. What the heck? Okay. I will say I'm remembering now that this particular expert, when I was reading their affidavit in this memorandum, I'm remembering that I thought this person didn't make a whole lot of sense. And I'm feeling the same thing now where I'm like, I don't know if it's just because there's so many errors in terms of like the grant. Like, it's one thing if you've got a backwards quotation mark, like that's funny, but also annoying. But like, you still get it. It's a quotation mark. But like, if this is an example of where a lot of this is not really objection unintelligible, right? Because I can't even figure out what they're trying to say. It's actually, okay. So that's unfortunate, but maybe this person will be better spoken than they are at writing, but this should have been proofread. And it just, I don't feel like, look, I mean, why is this all one paragraph? Why? This is an entire page. Look, I mean, there's a new paragraph starting right here, but that's like, I'm sorry, what? No. Okay, we'll read the conclusion. I feel like I ended up doing this before with that memorandum. I was like, this is not working for me. Conclusion. All right, what's her conclusion? In conclusion, I do not find any supporting evidence for the prosecutor's claim that the defendant has failed to meet his burden of showing that the change of venue in this case is necessary based on the community attitude survey conducted by Dr. Bryan Edelman and research strategies incorporated on behalf of the defendant. In fact, in my opinion, I find the opposite to be true. Oh, right. This is the one from the University of, okay. This will be really interesting to see how they do on Thursday. You guys, if you didn't watch the video that I made covering this memorandum, definitely check it out because a lot of this will make a lot more sense. It's pretty funny. I feel like, well, I ended up laughing because there were some funny things. Like the typos were funny and then they got more annoying. And I had like flashbacks. That's right. This expert is the one I ended up goading a million times. I goaded a million times. I remember that. I goaded a million times because of the typos. Okay. Right. So, but that leads me to the next thing I was going to say, which is I promised you guys a game. Again, due to some of the funny elements of this document from when I covered it initially, that there were some words that were used so many times over and over again that it was really astonishing and insane. And I promised you guys a game, the Control F myself game. So without further ado, so this document, again, there's certain parts that are riddled with more typos than others, but apart from that, there's words that are used so many times I was laughing and I got kind of silly, right? Over time. It's a long video, but anyway, it's timestamped as always. But because some of these words were used so much, right? The three keywords I was going to do this game. So attitude, candlelight, and prejudicial. So anyone who wants to take a guess, this is a 319-page document. How many times do we think, or do y'all think, that they used the word attitude? I'm going to make a guess. I'm going to make a guess. I'm going to guess 38. So y'all get your guesses in. And I'll go ahead and make my guesses for the other two keywords while you guys get your guesses in. So the next keyword is candlelight. I'm going to guess with candlelight, I'm going to go with 22. And I'm going to write these down so I don't forget what my guesses were. And then with the third keyword is prejudicial. Oh man, I'm going to guess 74 on that one. So, okay. Anyone want to make a guess? Speak now or forever hold your peace. Okay. Cece, did you watch, did you catch up on I can't remember if you were there for the most recent live stream with Ezra, but if you were there for some of it or not there for any of it, have you caught up on it? And if so, I was saying to Dr. Bob how, because Dr. Bob has been on vacation, and I was like, we need you for helping us with this crime scene because he's got to, for you, those, because in case the two of y'all haven't met, Dr. Bob is a retired school principal and physics teacher and has a very good brain that can help us. So we need all brains on deck. So we're going to be going through all that on the next live stream. Yeah, I might have missed the end. Yeah, it was, we were finished. I mean, the way it ends is with the freaking Ezra's interviews with law enforcement about the homicide. And she, they confront her with finding the body and whatnot. That's how that, I mean, that was the very end of that. And the last like 2 hours of the live stream was that recording. So if you don't remember that, then you missed at least the last 2 hours. Anywho, all right, let's play the game. So Control F myself game. All right, we're doing attitude. And yeah, everything's timestamped too. So just make sure. And did you see Jenna Vandersand? We're getting to the end of the state's case in chief. Everything that happened in the last episode is insanity, and so definitely check it out if you are interested. So it's okay. So here we go. What's it gonna say? Do 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 do. Don't freak out. It always says that, but that's not ever true. Or why is it saying this? Hold on. Why is it saying that? Hold on, let me try this again. Is it that it's like too many times? Maybe. Possibly. I don't know why it's saying that. So I will say whenever I was doing like the sidebars, like definitely heard, like, and I would control F for something. Sometimes this would pop up and then it would have the number of times. I don't know why. I don't know why it's saying that. Maybe if I get rid of the other documents, I'll see if that helps. Loading results. Maybe I just need to be more patient. Is that ruining it when I do that? I guess so. Okay, hold on. Let me try this again. Maybe I just be more patient. Oh, I spelled it wrong. I'm an idiot. That's why. Sorry, guys. I'm an idiot. That's why. Good job, squirrel. Spelling. Okay. Freaking typos. All right, here we go. Look at that. Wait a second. Y'all, I wasn't joking when I said this game. Okay, look at this. Exact matches. So attitudes and plural counts. 75. 75. What did I say? That's insane. 75, you guys. 75. My brain is exploding. I guessed, what did I guess? 38. Wow. 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 So maybe you guys can see why I made such a big deal of it when I made the video on this, because I was like, wow, these words are being used over and over again. Wow. 75 times is a lot. Okay, let's move on to candlelight. My guess was 22. All right. And then the last one was prejudicial. I'm thinking I should up my guess considering how off I was on attitude. I'm going to change my guess. My guess was 74. I'm going to change it. I'm going to change it to 108. Let's see how close I am. $63. Really? 63, it says. All right. Well, there you have it, guys. So attitude wins. And honestly, it was really insane. So it doesn't, 75. Wait, 75 versus what was this one? 73? 63. Yeah. So attitudes wins. The control off myself game. Shout out to attitudes. Woo-hoo. You get a prize. I don't know what it is yet. You get the control off myself prize. So, okay. So that's it for the rest of these documents that, again, if you didn't watch that other video though, you can, it's covering this 319 page document. And I think, I'll link it in the video description. If it's not already linked, it might already be linked. But in fact, maybe it is now that I think about it. So yeah, but anyhow, this hearing will be on Thursday and I will cover it, and it's going to be spicy as all get out. And I'm going to make a spicy Santa for Prosecutor Santa in his honor for that. And let me pull this up here. So for CC, who is made my day by being the person who does not know about this case, as we wait, add to stage. Here's the slideshow. So we can give you a little familiarity here, okay, as we go through this. So this case, Bryan C. Kohberger, okay, this is a quadruple homicide out of Idaho. All right, here's a little rundown. Quadruple homicide out of Idaho. Bryan Kohberger is accused of the quadruple homicide. There's Moscow, Idaho. And this was 4 college students who were living, or well, one of them was staying overnight with his girlfriend. The other were living there, but in a house. There's the courthouse. And this was like 4 a.m., approximately 4 a.m., somewhere in there, that the murders happened, and it was with a knife. And part of the thing that makes this case really interesting, Cece, and for anyone else who also doesn't know about this case, is that whoever did it, okay, was in and out in 16 minutes. 16 minutes. And that's the maximum window. That's the maximum, being as generous as possible based on the evidence that we know of. And we don't know a whole lot, but from what we know, because of where the car was cited and whatnot, and the cell data and everything else, you know, there's the DoorDash driver, that 16 minutes to have parked the car, gotten into the house, and it was what, 3 stories, right? Gone all the way upstairs, right? Potentially checked 1 bedroom and realized it was empty, stabbed 2 girls to death, and then gone down to the lower floor, which is the middle level. This is my interpretation of it, right? You know, without going into too much detail, but and then stabbed the 3rd roommate, another female, and then her boyfriend, right, Ethan. So there was 3 females, 1 male, stabbed and then got out. And left 16 minutes. And they still haven't found, just for anyone again who's still haven't found the knife. Yeah, it's pretty insane. Yes, it's insane. Still haven't found the knife. But the suspect left a knife sheath at the scene, right? Is it on accident? Was it on purpose? We can talk about that. In fact, I've got a whole PowerPoint presentation I've been working on. Anyway, but the DNA on the knife sheath, this is the big thing. The DNA on the knife sheath, there's a button snap. They have the DNA there, is like, there's no way around it. It's the DNA that matches the suspect in this case, right? That's the big thing. That DNA is the big thing. And the knife sheath was found underneath one of the victims' bodies. So there's other evidence, but like, that's, you know, hardcore, right? So, and the suspect is, you know, rightfully so and smartly not said a dang word, kept his mouth shut, maintained his rights. Good for him. And another thing that makes it kind of interesting is this suspect was interested in criminal justice and actually had studied at one point with a professor who was like mentoring him. And this professor is the expert on BTK. Oh my God, why am I blanking on her name right now? She's the expert. Oh my God, what's her name? Hold on. Let me see. Dr. Ramsland. Yes, Dr. Ramsland. And she wrote the book on it and everything. He studied under Dr. Ramsland, which is like, she's the one like got inside BTK's mind and all that. So Dr. Ramsland, he studied under her, and she like, seems to be like his mentor and whatnot. And, it's interesting. There's a lot of interesting factors in this case. And, I love a good puzzle. That's why I love the Ezra crime scene is a puzzler. One big puzzle on this one so far is how the heck did someone get in and out in 16 minutes, right? And then another overlap, Murdoch, right? The cases I love, right? It's like, how did he get out of there so quickly, right? How did he get out of there, get to Alameda so quickly? I love these mysteries. And so, and there's a lot of mysteries in Ezra's case that we've been working on. So, but the other thing about this case for CC and anyone else who isn't aware is that this is a death penalty case, okay? And this suspect, this defendant, has public defenders and one of his public defenders, his lead public defender, Ann Taylor, is a freaking boss bitch in a good way that is freaking just a hero in my mind. Okay. Like this is her part of the reason I wanted to start covering is because her the lawyering is so good, and I love the judge. Cece's, wow, look at you learning, catching on quick. Yes, so here's what I can say about that, and this is all in the PowerPoint that maybe I'll finish someday. One of the things that was in the probable cause affidavit, if I recall, I'm paraphrasing, right, is that his cell phone, how many times was it? His cell phone had pinged at that house, right? When they do the GPS cell phone towers, some 16 times or something, a lot of times, okay, before the night of the murders, and always in the middle of the night. And then his car, if it was him, right, the white Elantra was seen, right, in that area, circling around the house at the time of the murders, again, middle of the night, but the cell phone went silent, right? So airplane mode or powered off, something like that, right? For that window of time, and then came back to life, came back on. And then this is the other thing that's kind of crazy. So again, the murders were in the middle of the night, and then one of the roommates, right, who, woke up and then found the bodies or whatever, law enforcement was called, like, I think it was like 11 a.m. or something the next day, right? Because these are college kids. I think it was a weekend. So, but here's what's crazy is that before that happened, I'm going off of my memory because I've been Ezra brain, but I'm thinking it was around like 9 a.m. or something. So after the murders, right? But before law enforcement had been notified. This suspect's phone, and I believe his car was also seen. So both, again, pinging at the house, coming back to the scene of the crime. Potentially, maybe realizing he left the knife sheath behind, right? Potentially, or potentially to see, are they there? Is there police yet? Like, has anyone seen anything yet? Right? Just to see. Isn't it wild? What time exactly? What? You mean like when the murders, or when they? I don't know if I have the probable cause affidavit handy. Let me see. Let me see. This might be it. Hold on. I might be able to pull this up. All right. Yep. Hold on. I think it's in here. So, okay. Scroll. So, I'm looking for that part. So crazy. This is the other thing that's really chilling. So one of the roommates, because there were other people that lived there. One of the roommates, by the way, this part's wild. Okay, I'm gonna read just this little part before I answer that question. So DM, this is one of the roommates. Stated she originally went to sleep in her bedroom. Now this was on a different floor. Okay, DM was on the very bottom of the 3-story house. DM stated she originally went to sleep in her bedroom on the southeast side of the second floor. Or sorry, never mind, second floor. Awoken at approximately 4 a.m. by what she stated sounded like Gonsalves, that's one of the victims, playing with her dog in one of the upstairs bedrooms on the 3rd floor. A short time later, DM said she heard what she thought was Gonsalves say something to the effect of, "There's someone here." A review of the records obtained from a forensic download of Kernodle's, that's another one of the victims' phone, showed that this could have also been Kernodle, as her cellular phone indicated she was likely awake and using TikTok app at approximately 4:12 a.m. In my PowerPoint presentation I've been working on, I think that this TikTok thing is vitally important, and I bring that up because 4:12, she was on TikTok, and there's no way that the suspect was not in the house and probably stabbing people right above her, and she didn't hear it or didn't. It's wild. There's really no way around that being the case. DM stated she looked out of her bedroom but did not see anything when she heard the comment about someone being in the house. DM stated she opened her door a second time when she thought she heard what was someone crying coming from Kernodle's room. DM then said she heard a male voice saying something to the effect of, "It's okay, I'm going to help you." At approximately 4:17 a.m., a security camera located at 112 King Road, a residence immediately to the northwest of 112 King Road, picked up a distorted audio what sounded like whimper followed by a thud. DM stated she opened the door for the third time after she heard the crying and saw a figure clad in black clothing and a mask that covered the person's nose and mouth walking towards her, and then described the bushy eyebrows. And then from there, at that point, I'm sure she went into the, I don't even want to know. Anyway, they believe the homicides occurred between 4 o'clock and 4:25. And then suspect vehicle 1, let me see if I can find multiple sightings starting at 3:29 a.m. until 4:20. So it's, I'm going to be more specific, Dr. Bob. It's not 4 o'clock. Okay. Here, check it out. Check it out. I know. My PowerPoint presentation is called Unraveling the 16 Minutes for a reason. So suspect vehicle 1 can be seen entering the area at fourth time at approximately 4:04 a.m. So that means the suspect is still in the vehicle, right? If it's the suspect vehicle, they're still in the car at 4:04. It can be seen driving eastbound on King Road, stopping and turning around in front of 500. So this is when does that 3-point turn, and that's on camera, and that we've seen that, right? The 3-point turn. Okay. It appeared to unsuccessfully attempt to park or turn around on the road. It then continued to the intersection of King Road. This is at 4:04. So that's what, when I said 16 minutes is generous, that's why, because they're still driving and turning around and parking. 16 minutes is the max. Like what would it take doing all this, right? Maybe 2, 3, 4 more minutes, right? But the 4:20 is the maximum stop time. So 16 minutes is the maximum, which is insane, because really it has to be less than that, right? It's then seen departing at 4:20. So that means out of the house before 4:20. It's insane, right? Oh my gosh. So then let's find the thing. There's the worst map of all time. I've joked about that before. Look at that. Look at that. It's incredible that's Ann Taylor handles this map beautifully in the last hearing that they had. I'm sure I commented on it. So let's get to the part about the other thing with the pinging. Okay. Okay. The possible route. That's interesting. I forgot that stalked was used in here. The prosecution has not said he stalked. Now, stalking is different, right? Stalking is a whole separate thing that you can go into. Like, that's why they're able to say, well, we didn't really say that. I'm sure, I know I addressed that in the PowerPoint too, but that speaks to more of a psychological thing than what I don't know how to go into that without like 3 hours of things, basically. So we will delve into that with the PowerPoint. So I'm just trying to find the pinging. That's what I'm looking for here with after the fact. Another terrible map. Let me see if it's in my PowerPoint. Show you guys what I have so far. I'll show you guys what I have so far, I guess. I don't know how this will work on here. Let's see how this works. Okay, you guys are getting a sneak peek. I've been working on it. Okay. Oh my gosh, I can't even believe I'm showing you guys this. This is a work in progress. This is me Scroll-Lock Holmes. Let's see. I haven't looked at this in a long time. So a lot of what this has to do with is what I've learned from Dr. Bricado. So there's a lot about that. So these are Dr. Bricado's predictions from before a suspect was ever announced. These are some other key things. Yeah, that's I put a lot. Yeah, I'm not remembering now what I was doing with this. And yes, okay. So the weapon matters. This is really more of a psychological profile based on what the experts say in terms of who could have done this, like the psychology of it, right? Serial versus mass killer, continued. This is actually probably pretty educational. Significance of the dark, because the house was pitch dark, by the way. The house was pitch dark. House was pitch dark. On playing God. Shout out to Dr. Bricado for and he's such an incredible person. All of this stuff was from before somebody was announced as a suspect. Okay, let me scroll down. What is the significance of the mistakes that were made? I mean, there's a lot. The knife, its sheath, and its snap. So instead of me spouting squirrel theory, like I'm quoting experts, but I had gone through and put a lot of the expert information and organized it. There's this whole thing with Papa Roger. That's really interesting. And then the experts had remaining questions. And then my goal here is to try to answer their own questions with their own information that they had said previously, like at different times, basically, if that makes any type of sense. So background knowledge and insight plus facts of the case equals unraveling in 16 minutes. So this is where I started going down this is a whole thing. Okay. Yeah. Wow. I remember now. See, you can see where I hadn't quite finished editing some of these slides, and then some of them are not. Yeah. This is kind of where I left off. So trying to organize all of my scroll thoughts. And I have basically, and also, by the way, all the information, I have a huge Word document that's typed up just like all the different things. And so I was going through the Word document and then trying to organize it into this PowerPoint. So that's where I'm like transferring it. Anyway, that's the PowerPoint. Anywho, I know, Mr. Nelson. Shout out to Mr. Nelson. I know. Hold on. We need to do something for him. Mr. Nelson. Mr. Nelson. Oh my God. There's so much good stuff in that trial. I love it so much. Cece, if you didn't see it, there's Mr. DeFore has his exhibits, and it's like his happiest time, and it's like a 3rd grade school project, and he's like, oh my God, you just have to watch it. If you didn't see it, like he gets so excited. It's amazing. Everyone loved it. Poster boards, and every time he gets to use them, you can just see it's like his best day. And it's like, oh my God, we just were joking, he used the glue stick, and like, it was amazing. We love it. We love it so much. We can all see with our eyes. Thank you, Mr. Nelson, for that one. I don't want to make you have to do things. There's also no probative value. And this one we added last time. Last time we added, I'm that liar. And then it used to say maybe Ezra. Well, throughout the course of the last live stream, I deleted the maybe. It's like, nah, we're getting rid of the maybe. I'm sick of the maybe. Jason Mangle, there was always just one more lie. Oof. Wow. Another good case. I love it, man. He is a legend. He's a legend. So I love, y'all, for those of you who haven't heard, I was raised on like Alfred Hitchcock movies, right? Like Plain Clue. Like, I love the law. Like I love court documents. I love the law. I love trying to figure out legal strategy. And then equally, I love trying to solve a problem, solve a mystery. So that's why I love doing this, right? That's why it's almost better that it's almost better that there was a gag order in terms of Bryan Kohberger, right? And that it's very limited information, but the information that we have is accurate because it's from the court record. And it's that, the probable cause affidavit, and then following the hearings and the court documents. And you really have to think it through so that you can try to make sense of it, but without jumping to conclusions and stuff. So it's a real puzzle. How that happened in that window of time is a puzzle. And the Ezra, dude, y'all, if you guys could see, like in that slideshow I just was showing you guys, that slide where it's like, this is me, and it has that map with the red strings. Honestly, that is me, but times a million with this crime scene. And not just the crime scene, the timeline. There's a lot of it's so good. It's such a good mental exercise, right? It's good lawyering. There's a lot of great legal argument. There's a lot of great legal problems and questions. The judge is phenomenal. They put everything on the record. Those housekeeping sessions are amazing and just awesome. I feel like we're learning so much. We're seeing such good lawyering on all sides. And then on top of that, to boot, you have a really good crime scene. Like, by good, I mean, it's a tough one. There's a lot of things that are like, how the heck, right? What does this mean? And what is, it's got all the things, just like Murdoch too, right? So anyhow, nope, do not know. Good question. We don't know. And I know that is one of my things that I'm going to be addressing in the PowerPoint. It's not made it onto a slide yet. I think it's just in the Word document. That PowerPoint presentation is going to be really long if I ever finish it. But I know I had thought to myself potentially about the fact that, so one of the victims, the one that was awakened on TikTok, she had ordered a DoorDash delivery, and that DoorDash delivery was delivered. That driver is not the suspect, but that they would have been like, one of the things that it seems like happened was one of the times when the suspect potentially attempted to park and then get into the house. They saw that the DoorDash was coming. They would have passed the driver, right? That would have happened, or they would have seen it happening. They would have seen that delivery. There's no way around that. And so potentially, if the door was left open or maybe left unlocked, right? Because one of the victims, right, Xana Kernodle, she came down and got the food. The food was not left, came down and got the delivery, right? That's confirmed. Went back up with the food, was eating the food, was on TikTok. Eating food and on TikTok at like 4:12 when the suspect got into the house somehow, right? There's been talk about potentially through a sliding glass door. Let me pull my slideshow back up. Oh, there you go. There's the house. So, by the way, let me pause it right here. By the way, this picture on the screen, see where that caution tape is, and see that window where the caution tape is? Right by that tree. Initially, there was a cinder block there, okay? So, initially, there was a cinder block there at that window, which is an interesting point, right? There was a cinder block there. And I think the window was maybe unlocked as well, but there was a cinder block. So there's the house. And so there you go. So on that second floor, which is really the main floor, you can see sliding glass doors. There was talk that potentially could have gone. I mean, really, we don't really know because of the gag order. We don't know much. But thinking through it logically, these were college kids. They'd been out drinking. Were all of the doors and windows locked and secured? Probably not, right? I think that's kind of a safe bet when you've got, especially it's a place, I think there were 6 roommates, and then they had significant others staying over. There were times where there were people that were like strangers partying in the house. It seems like the type of thing where when you've got a lot of people coming and going, and even if you just have 6 roommates, it might be more hassle to lock it, right? I don't know. So a lot of that matters, and there's, we'll talk about it, but in the PowerPoint and stuff. But it's a very small college town where everybody felt safe, right? So it's going to pull up some more pictures here in a sec. All right, so there's the kitchen and there's those sliding glass doors. So that's one of the thoughts is potentially could you come in through those sliding glass doors into the kitchen. This is, you know, this is the actual house. Another picture of the sliding glass doors. One of the bedrooms on the second floor, which again is really the main floor because of the split level situation. Again, that's on the main floor. It was like a 6-bedroom house or something crazy like that. Again, that's the main floor. What gets interesting is when it goes up to the top floor. I think that's still the main floor. I tried to put it in order so that it goes upwards. Okay, so now we're upstairs. Now we're upstairs on the top floor. So there's the bathroom on the third floor. I'm pretty sure that's yeah, it is, because I remember I had a question. So there's like a panel on the ceiling there, and I don't know what that is. I've tried to figure out what that is, and I can't figure out what that is. There's a panel on the ceiling there of the third floor, and in the pictures, it's like you can see that there's a panel there, but you can't tell what it is. And I was like trying to think, is that like an attic? I don't know. It's just interesting. I don't know what that is. That was one of the things I was wondering about. Oh, there you go. Sorry, there's a better picture. See what I'm talking about, guys? I've not heard anyone raise that question or give an answer. Like, I've not heard anyone talk about that. Like, that to me, what is that thing? What is that thing, man? This is the third floor. What is that thing on the ceiling? I'm glad that I found a better picture that includes that. Well, crawl space would be below. Well, at least here in the US, crawl space is underneath. It's in the dirt. That would be up above. Okay, pull down attic. Okay. So, you know, thank you, Dr. Bob. I mean, you see what I mean, though? Like, do we need to be considering? I mean, I can't fathom that in max 16 minutes. Again, that's being generous. It's probably more like 12. Coming from an attic, I don't know that that's, well, we know that didn't happen because the vehicle was parked. I don't know. Anyway, it's just interesting, right? It's just interesting. Attic. It could be creepy, right? In this situation. So and this is the third floor, right? Coming up those stairs. They had a lot of the big windows, right? So from the road, the house is great. Well, it doesn't exist anymore, but it had all those windows with lots of natural light. But you know what? Think about it, right? Look, you can see everything has big windows in every picture, right? All facing that front side where the road is. Now this is on the bottom floor, the first level, which is half underground, right? Split level. This is the laundry room thing. It has a little sink there. I know I included that for a reason. I can't remember what it was, but I had a thought about that. It's probably in my Word document. I had a thought about that when I saw that picture, and I was like, So I made sure to include it. Thank you for letting her know, Dr. Bob, that the horse, oh my God, the house is torn down now. Yeah. So, so there's the courtroom that we're so used to seeing all the time for the hearings. That's what isn't this picture cool? This is the old, this is the Latah County Courthouse back in the day. And then what happened was, like, I think it burned down in a fire or something like that. Isn't that crazy? Yeah, they tore the house down. Don't even get me started. So that's like a whole thing. I was so shocked when I learned that Moscow, Idaho has mountains. This is Moscow, Idaho. This is why I love covering stuff. I was like, what? Pardon me? What? I'm picturing cornfields and there's mountains. I mean, I've never been out there. Obviously, I don't even know if Idaho has corn, but potatoes. I don't know. I did not expect that. Isn't that insane and also beautiful? Now this is cool. So this is a map made in, I can't remember. I'm sure the year is on there, but it's really small and hard to see. This was done in like bazillion years ago. I don't know, 1800s or something, like the real deal. Like someone made this map of Moscow, Idaho. I thought it was cool because, historical. Yeah, back to the house. So, y'all, I have to go teach a violin lesson for someone on the West Coast, but I can't say enough about this case that we've been doing with Ezra McCandless. Highly recommend catching up for those of you who have been following it, or again, kind of jumping on in if you want to catch up. I really want to have the next episode done for tomorrow. I don't know that I'll be able to pull it off because as like with any good case, right? Each question leads to another question, which leads to another question, right? Like we had with Murdoch. So as I'm trying to answer one question, that's what happens, right? And so I've got so many projects and so many lists going with things I want to answer. Now I'm going to have to just decide which questions are we going to leave for the next episode after this one, right? In other words, if I limit the number of things I try to do and questions to look into before the next episode, I'm sure I could have it for tomorrow. So I'm going to try because I know I can't wait for you guys to see Ezra taking the stand. I can't wait. This is going to be, I can't wait. I'm so excited. So, that is a big motivation for me. If I just keep thinking about that, I can limit my questions and I can get it done for tomorrow. So I'm going to try to make sure, but in other words, just keep an eye out. I'll post it, upcoming videos, but yeah, everything's always time stamped, really detailed, as y'all know. So if you want to do the catching up and whatnot, there you have it. So, okay. Well, no spoilers at CC. But then, I'm thinking then why I'm saying that, because, I couldn't remember. I know a couple people of the Squirrel Crew had seen some of the trial, but I couldn't remember. So, most people haven't, so, but yes, good night to you guys. Thank you for being here. Squirrel Crew is the best. And again, this hearing will be on Thursday, so I will cover that as well. It's going to be insanity, as I've said. So yeah, so thanks everybody for being here. Thanks for being a squirrel. Love you guys. And I'm going to roll out, squirrel out with the outro when I can find it. And there we go. All right. See y'all next time.